I respect that, Senator, I really do. I'm Jane Page Thompson, and I'm from Aiken, South Carolina. You said at the beginning of this meeting, in your 18 years, you didn't remember suspending the rules. I remember a day that you did. It was June 16th of last year. You all suspend the rules out of rote. You suspend the rule that requires a paper printing of certain bills in order for timeliness to affect the process.
That's the waiving of that rule,
well,
which is provided for in our rules.
It is, and you all have a great set of rules. I love the description of where you point on your nose and your eye to determine a yay or a nay. I have one question to ask.
Sure.
I've heard Senator McConnell talk a lot about his fervent belief that this is unconstitutional. I've heard Senator Knotts and you make your points about your concerns. Can I ask Senator Davis why he truly believes it's not in a violation of the Constitution and why he is supporting this bill?
Sure, you can. You may.
Okay.
Well,
as a lawyer,
and again,
you are uniquely qualified.
He made that on the floor, and he did a very good job. I heard what he said.
I think, thank you, Mr. Chairman, for allowing me again the courtesy of appearing. I know it is a breach of the rule.
No,
and I appreciate you letting me. But I think three things. As Ms. Gray indicated, it is simple language in the Constitution where it says each house shall choose its own officers and determine its rules of procedure. My first argument would be that's fine in regard to how the Senate conducts its business, the role, the order of business, when things get taken up, and this, that, and the other. But when you talk about something as fundamentally important as the citizens knowing how their representatives voted, that becomes a substantive matter. That's no longer just a matter of process. That's no longer a matter of how the Senate chooses to conduct its rules. It's no longer, it gets to the heart of things. And so the first argument I would make is that when it determines its rules of procedure, it doesn't extend to the outcome, the product, the substance, which is the vote. So that would be my first argument. The second argument I would make is that even if you consider it to be a matter of procedure, whether a recorded vote is a procedural matter, there is a Supreme Court case right on point that says that while the Constitution empowers each house to determine its rules and proceedings, neither house may by its rules ignore constitutional restraints or violate fundamental rights. And it goes back to what the gentleman said earlier. There is a hierarchy. There is a hierarchy. You have laws, you have rules, you have the Constitution, and then after that, even before there's a Constitution, there are certain inalienable rights. There are certain fundamental things that you cannot violate, And I think that's what the Supreme Court is getting at in the Coleman case, is that even if this is a matter of going to procedure, which I don't think it does, I think it's a matter of substance, but even if you contend and argue that it's a matter of procedure, I don't think that rules of procedure can be used in such a way as to deny a fundamental right. And that's just not Senator Tom Davis saying that. That's our South Carolina Supreme Court. And lastly, I will say this. The Constitution allows the House and the Senate to determine its own rules of procedure. There is absolutely nothing that says that they can't determine what those rules of procedures are by agreeing with the House on this is what we're going to do. It is a mechanism whereby the House and Senate have decided to pass the rules of procedure. There's nothing in the Constitution that makes rules sacrosanct. Okay, rules is a small letter R. Okay, it's not a term of art, and it talks about the way we're going to conduct business. And if the House and the Senate decide by majority that they want to conduct the rules of procedure by adopting a statute, there is nothing in this Constitution that prohibits that. Those are my arguments.
Well,
thank you very much.
Thank you. Thank you. Well, we'll have another good argument, and I hope that I'm going to get the recitation of the Coleman Court for both of us, Senator Buford, so we can both read the part that Professor Simpkins left out that I think defeats the whole argument that was made in that. At least that's I haven't read it in its entirety, but that's sure the way the plain meaning of that Coleman case sounded. But with that, any motions?
Yes, sir. Unless there's somebody else to be heard, I move we adjourn.
Move we adjourn. Motion is we adjourn. Any objection? Hearing none, so ordered. The committee will stand adjourned. Thank y'all so much.